This is Chris Osborn, and this is part 2 of an orientation to family law in North Carolina, trying to help you understand your options when facing separation and divorce. In part 1 of this very short video series, I talk about the legal issues that come up when you are facing a separation, and it depends on whether you have kids, whether you have acquired property. There are a number of different things that might have to be addressed. This video focuses on process. This focuses on how are we going to get there? Your ship has run aground on Separation Island. If either spouse wants to initiate a separation, then a separation is initiated, and there's not anything the other spouse can do to stop that. And therefore, separation is all about figuring out what happens while you're in this limbo state. Because again, as we covered in the first video, it takes a year of being separated before you can actually get a divorce. This video focuses on how are all these issues dealt with? How does a couple that is separating figure out the division of property if necessary, the terms of a custody and visitation agreement, or the terms of spousal support or alimony? And so I'm going to give you a little chart here that I created to explain your different options that you have in North Carolina for addressing all these issues. And I've got a chart that basically, if you picture on the left side, on the axis going up, those factors or those arrows represent time and cost. So as you move higher up the chart, you're talking more time and more cost. And on the bottom of the chart, you're going to see arrows for party control and privacy. The first category means how much control do the parties have over the process, over what happens and over how their decisions are made. And that tends to go hand in hand with the other factor of privacy. Is the process that the couple chooses one that is part of the court record and involves pleadings and possibly hearings and trials, or is it something that they handle themselves? The farther to the right that you go, you will find solutions or processes that have more party control and more privacy. And the higher you go on the chart, you have processes that take longer and cost more. And then there's another arrow that I put on here that is super important as well. And it's messing with algebra teachers are probably going to give me a hard time about this, but I got another arrow on here. This represents stress. And as you can imagine, the more control you have and the more privacy you have and the less time it takes and the less cost there is, why? The less stress. The closer you get to the higher left side of the chart, where you have very little privacy, very little control, and high cost and high time, it's more stress. And that's, I think, pretty much mathematically provable. It's not really a subjective opinion. There might be some subjective opinion on the next part on where you put the various solutions, but I'm going to give you an overview of all of them because you are entitled to be able to make a choice about the best way for your family to deal with these issues that have come up. The most controllable thing and the most cost efficient and time efficient is sit down at the kitchen table and write up a list of what you're going to do and basically work it out yourself. If you're viewing this video, chances are you probably are already recognizing that may not be a workable solution. It may be too complex. It may be you don't have enough trust. This method, which many couples use at least to work the basic details out when the issues are simple and it's amicable, often in short-term marriages that didn't last very long, certainly when there's no kids, but it requires still a very high level of trust and cooperation. It requires effective communication skills, and it requires that everybody have equal knowledge already, say about the finances and about what decisions have to be made about different debts and assets going forward. It also requires, if there are kids involved, everybody's got to really be on the same page that, hey, we're trying to look out for the best interest of the kids. If there's any battling over kid time as a weapon back and forth, this is not going to be a viable solution. It's going to work very well. And at the end of it, even couples who take this kitchen table approach are probably going to want to have a lawyer or two involved to draw up the final agreement, because unless they're lawyers themselves, you might miss something. And even if it's an amicable agreement, you're trying to plan not just for the immediate future, but also for things that may have impact down the road. There also may be court orders necessary. And of course, the divorce process, the actual legal entry of an order of divorce, which happens at the end of the 12 months, it's an easy procedure, but it is a legal procedure that requires service of a complaint and filing of a motion and that sort of thing. So you still might need legal help, even if you choose this option, but you're not going to have a whole lot of legal help involved, and it won't be a very expensive process. The next option, moving just a little bit upward on the chart of stress and upward on the chart of cost, and a little bit less party control, a little bit less privacy, but not much, is pre-litigation mediation. And this is where a couple would sit down with a neutral third person. They still don't have their own counsel involved necessarily. They find a neutral third person to assist the parties to negotiate. This would be something that they voluntarily agree to. And the mediator is, again, in this situation, just a facilitator of negotiation. The mediator is not a judge. They don't decide things. If the couple disagrees, the mediator doesn't have any power to make one party or the other do anything. And a mediator can at least help identify the issues, all those things that we talked about in part one, what has to be decided, because sometimes a couple may not have thought of all the different pieces of the puzzle. And the mediator can identify the issues with them, but the mediator is limited in a very important respect. They can't give any legal advice to either side. Sometimes people will contact me about having me serve as a mediator for a separating couple. For that to happen, first of all, they got to really both contact me, because if I talk to one of them and I get much of the story of why there's a separation divorce happening, that kind of puts me in an awkward position. I've already got some knowledge from one side, and the other side may not trust that I'm going to be neutral or fair. And so typically, if a couple comes to me together, I will talk to them about doing pre-litigation mediation, but I have a lot of hesitations about serving just as a mediator. I think particularly in a complicated situation, everybody benefits from having some counsel involved. But the good news about a pre-litigation mediation is there's no obligation to reach an agreement, and it's private, it is confidential. You'd probably be sharing the costs, and you'd probably be very forthright about sharing information, and it won't work if you don't share information for the other person to be able to make an informed decision. This requires pretty decent communication skills as well, and requires a high level of trust, particularly if you're not going to have an advocate or an advisor. So I recommend pre-litigation mediation when the issues aren't too complex. There might be a few sticky issues where you need some help, and the parties are at least open to cooperation. And you can do pre-litigation mediation with lawyers involved also. It's a purposeful commitment that you would make. Hey, we're going to try to mediate this and not have it go to court. And as I'll talk about later, there's also sometimes a required mediation if you are in the court process. So you'll hear that name thrown around a good bit. The next option that is on the scale, and let me see if I can pull out just a little bit so you can see where we are on the big picture here. We're moving a little bit backward on the scale of stress and backwards on the scale of party control and privacy. And we're moving a little bit more investment of time and higher costs, but this is a kind of almost a not quite middle of the road option. It's called collaborative law. You may hear it referred to as collaborative divorce or collaborative family law. This is a solution that is also geared towards staying out of court, and in fact involves a commitment to stay out of court. In this method, though, in this process, each party hires a lawyer who is trained to use certain negotiation tools and trained in how to communicate and help people who are in a high conflict or a conflict situation, as often is the case in a separation and divorce. Emotions are running high. There's hurt feelings. There's feelings of betrayal often. And there's a lot of confusion and fear about the future. So collaborative lawyers engage in what's called interest-based negotiation. Collaborative lawyers positions and say, we're doing this and you can take it or leave it. And they don't push hard and negotiate in ways that are bullying or pushy or focused on staking out a position and then moving back and forth in some kind of battle back and forth. It's interest-based, meaning each party needs to listen to what the other party's interests are, because both parties have interests, and both parties have interests that may overlap. If they both care about the well-being of kids, if there are kids involved, then that's an interest they share. But then they are going to have interest in how much time they have available for work and other items in their life, and interest about convenience, things like that. In collaborative law, the collaborative lawyers engage in cooperative problem solving. We treat the separation as an opportunity for problem solving. Each issue that has to be decided is not a dispute, is not something to fight over. It's rather, okay, we have this problem. How are we going to solve it? We need to arrange for some amount of separation for somebody because they haven't had any income and the other spouse has had lots of income, and how much the supporting spouse pays to this dependent spouse is an issue to be decided. It's a problem to be solved. And if we look at it as a problem to be solved, that gets us away from a battle to be fought. It gets us away from saying you have to, you must, the law says this, no, the law says that. And that's one of the things that makes cooperative a much less expensive option than the court litigation path that I'll talk about in just a minute. Another thing that collaborative law allows us to do sometimes, where it's beneficial to the parties and they agree, is to bring in joint experts. If a party has a stock or an asset that needs to be valued, and there might be disagreement over what the actual value of that asset is. For example, a business or a business opportunity, if it's been formed, is something that's often difficult to value. There are certain tangible assets it may have inventory, it may have equipment, it may have a website, things like that. But there's also goodwill, there's also time and money invested in it, there's also perhaps revenue, things like that. Businesses are notoriously hard to value. And when the parties can't agree on that, if you're going to court, then it's about proof. It's about what will expert witnesses say, and everybody's getting their own separate expert. In collaborative law, what the parties agree to do is get a joint expert. They jointly say, who's the best person to value this asset or to tell us about how to set up the custody arrangement for the kids. We have a kid with special needs, and we don't know if we want to do week on, week off, or month on, month off, or what we do. We bring in joint experts who provide guidance. The couple still has the power to make decisions, and the expertise is a tool that's useful for that decision-making process, but it's not binding. It's not a decision that is imposed on the couple. And so when people are interested in collaborative law, they enter a collaborative law participation agreement that says, this is how we're going to do this. Our lawyers are going to be working for a resolution, and that's all they're going to do. And this is important and a very sticky thing for some people, but in the purest form of a collaborative law process, the collaborative lawyers commit to, if this doesn't work, if we don't get everything worked out, we step away from the process at all. And if you're going to go into court and fight and have litigation, you get new lawyers. It sounds strange and frustrating to a lot of people at first, but there's a couple really good reasons for it. One is when you have a collaborative lawyer, that their commitment and their only interest is helping you reach a resolution. You know that there's no possibility that they're going, well, it doesn't matter if you don't settle, because then I'll just keep being your lawyer for litigation and I'll, get to earn more fees. And not that people do that manipulatively or purposefully or meanly necessarily, but it's a worry sometimes. And collaborative lawyers, we just don't want you to worry that's even a possibility. The other reason that it's important to have that commitment, and in most cases the commitment is there, is it lets the parties have something to think about. If you're going to withdraw from the process, if you're going to get out of this positive, forward, future-oriented process, you want to really think about that. And you want to not do that just on a whim and say, I'm just shifting gears with the same lawyer. It works that there's a little bit of a pinch, so you're going to have to go start over in the process. It keeps people at the table in a healthy, good way. But it lets you also preserve, if you want to go and fight, there's an option to do that. It's just, it lets us collaborative lawyers focus on one goal and one goal only. And we appreciate that. Collaborative law also requires and involves the sharing of all relevant information. We don't have fights and battles in collaborative over whether parties get to see each other's salary statements or medical records if they're necessary or anything else. We share that information. We get things, gather them on, each party gathers what they have access to, and we pull it together so we're all looking at the same information and the parties all are fully informed to make decisions. Another place where we sometimes use joint experts if necessary in a collaborative law situation is actually if we need medical assessments of one party or the other. Don't typically do that if kids aren't involved necessarily, because we're not worried about who's going to be left in the care of whom. But it can come up sometimes in relationships where there aren't kids, usually not though. You usually are saying, look, I'm just not going to be in a relationship with you, and so you can do whatever you want. The other thing about collaborative is typically it's a series of meetings between the two collaborative lawyers and the two separating spouses. It doesn't have to happen that way, but we usually like at least to once or twice get everybody together and have discussions about, do we know all the information we need to know? Do we have all the information we need to have? And I've had cases play out very differently in this regard. I've not had many cases that have proceeded through 4 set meetings. There's at least 4 sort of times you might typically come together in the very beginning to sign your agreement, then to exchange information, make sure you've got all the information, then to do some brainstorming about possible solutions on the various issues, and then to put everything together and say, okay, let's negotiate this out. Let's figure out what's happening where and put together an agreement. And then there's always an agreement that has to be drafted at the end. And a written agreement is the end of all these processes if it's not a court order. But you don't have to have all the 4A meetings. I've got a collaborative case going now where my client hasn't felt really comfortable getting back in the room with the husband that she's leaving because of some of the ways that he's acted and treated her. And she has asked me to just keep negotiating with the collaborative lawyer, and she'll come to a discussion if she needs to. And it's working out okay. And we don't force people to get together if they're uncomfortable doing that. But the idea is if we do get together, it's for that purpose and that purpose only, to identify the issues and work through them, not for one of the lawyers to take a deposition or cross-examine or ask questions of the other party. That's only goes with other kinds of process. In the collaborative law process, we don't have depositions, we don't have pleadings, we're not, except for to wrap up the case at the end, just the administrative things, to get the divorce and maybe to divide up an IRA. We're not cross-examining, we're not trying to prove things because we're not worried about what happened in the past. We are trying to focus on what's going to happen in the future, like a mediation would be as well. And this is, again, very private and very confidential. I move it a little bit back on the privacy rating only because there are collaborative lawyers involved and there's 2 of them. But beyond that, it's completely private process. There's no hearings and no anything that anybody would know. The other aspect that's nice about collaborative law, and this applies to mediation in terms of party control, you meet whenever it's convenient for everybody, whenever it's convenient for the spouses and for the lawyers. And if you involve a mediator also. If a collaborative process is not successful, you still have an option of the parties having a mediation before they say, it's not working, we got to go to court. You have another option if the 2 collaborative lawyers, which I consider having a collaborative law process is having 2 mediators. The big advantage of a mediation is that each of those collaborative lawyers can give legal advice to their client. And so the clients at least have somebody that they can ask, what about this? What does the law say about this? And what would happen if I went to court? What are my alternatives? You can get some guidance that a mediator can't give. And then the collaborative lawyers also can help draft the final agreement that emerges if you do reach an agreement, which is something a mediator can't do. The mediator is going to tell you at the end, okay, go take this to lawyers to write it up, in which case lawyers end up getting involved anyway, although on a limited basis. So this option is best for any time when there are some legal issues to be addressed and when there are challenging relational dynamics. If the couple is not really sure, or either member of the couple is not sure they're going to be able to communicate with one another real easily, if they're worried about the dynamics, if there are imbalance of knowledge, imbalances of power, one party has more financial resources than the other, one party has all the information about the finances. Collaborative is good if, again, they're willing to share that information and don't want to have a fight about all that stuff. And if each party does want at least some kind of guidance. And so this is a method that I highly recommend. I have a bias towards this one. It is the methodology, the process that got me into doing family law in the first place, because this is the most humane way I can think of for a couple whose marriage is ending to work through the issues. Taking it to court, which we'll talk about in just a second, is just a bad fit for a lot of reasons, in my opinion. But please talk to other counsel, other lawyers, because they may have different opinions on that. Mediation is great as well. I'm a trained mediator. I'm a certified Superior Court mediator, but my hands are tied if I'm mediating a separation and divorce, and the couple if they don't have counsel, then I can't give legal advice and I can't draft their final agreement. Somebody else is going to have to do that. I will do that, but it's very limited the cases that I'll take on in that regard. If people are represented, then I can conduct a mediation, and I don't mind doing that. And then at least people have the advocate. But again, you have 2 lawyers and a mediator that you're paying for. So the parties have to be willing to work through their difficult issues, but it helps that they have at least some sort of commitment to preserving an amicable relationship. That's super important if there are kids involved. But even when there are not kids involved, you may still run into the person, see the person, and it's easier to do if you haven't had your lawyer eviscerate them on cross-examination, that's what all we lawyers do if we are in the litigation context. The next thing that is a possibility is negotiation or mediation in the middle of litigation. And this is actually basically when one party or the other has to go ahead and file feels like they need to go ahead and file an action to get the case on the court's radar and to say, we're going to need a judge to decide some things. Sometimes that'll happen if the enmity, the animosity is really high. Sometimes it'll happen if things are happening fast, like a spouse is saying, I'm moving to, Alaska and I'm taking the kids or something like that. In the middle of a litigation, you might be required to have a custody mediation. And you can also have your lawyers say, hey, let's try to steer this to mediation or try to resolve it mediation instead of going to litigation. But at least some court case or court filings have been drafted and processed. You might have some level of discovery happening, discovery being the exchange of all the financial information. If you've started the court process, then lots of times the attorneys are going to say, let's complete discovery, let's exchange all the documents, information in this formal process, and then we'll go to a mediator. And again, the mediator functions the same as the mediator we talked about earlier. They're not a judge. They can't impose a settlement. They don't decide things. And the parties are still negotiating and trying to agree. But it's in the context of, and if we don't, there's trial in 2 months, 2 weeks, or whatever. The proceeding, the mediation itself is private and confidential, but you're in the context of the court pleadings are not private. And so that's why this is a less private matter and a less party controlled matter, because you have the court deadlines in the background that are sort of driving everything. Mediator fees are pretty much always shared. That's whether it's pre-suit or in the middle of litigation. But if you have lawyers already engaged, then in this particular process, the lawyers are going to do most of the communicating at all. In collaborative, the parties and lawyers might get together and communicate, and there's nothing stopping the parties from talking to each other. I've had a couple collaborative situations, collaborative processes collaborative processes that ended when the couple sat down and they got to the kitchen table point. They actually said, hey, we actually see how this works. We can do this ourselves. We've worked through the last issues, write it up, collaborative lawyers. And we're like, great, that's fantastic, because that's a success. In this kind of mediation, the lawyers are typically going to do the talking and setting up for it. And the timetable, as I said, is driven by the court deadlines and rules. The cost depends on how much litigation process has happened before you get to this point. And so that's often a difficult determination. Where in the litigation process are we going to mediate if we've already started? At some point, the court deadlines are going to start showing up. And are we going to have done much of the discovery, as I mentioned, or are we going to try to do it quickly before and exchange information voluntarily beforehand? So this method is best, I think, when there is a lot of mistrust. Oops, sorry about that. Hang on just 1 second. This is best when there's a lot of mistrust and the parties don't really cooperate well, or when they've grown weary of the litigation process. Sometimes people come staggering into a mediation before trial and they're like, okay, this has been awful. Maybe we can settle it before we go to trial. And cases do settle at this point, and they can, but people are beleaguered and feel like nothing feels like a good deal really at this point, because you've already spent so much to get here. And you start realizing, how did I not try this to start with? And this is an option that is one that, let me start over there. So let me now tell you about basically, and we are way up, in case you have any doubt, we are up at the highest cost, highest time, highest stress, least party control, and the least of privacy. And that's submitting everything to a judge. And you might get one that looks better than this, you might not, but submitting everything to a judge and saying, judge, decide these issues. Decide who's the winner, decide who gets this asset or that asset, decide when the kids will see mom and when they'll see dad, decide how much alimony or support is awarded. You are turning the decision over to a judge. And in order to do that, all the information has to be exchanged through this formal process, because you're setting it up for a formal hearing. Evidence will be offered and admitted or denied, objections, all the things you may have seen in TV shows or movies. So each party has an attorney typically here. Now, some people litigate on their own without attorneys. Not usually the greatest idea. It doesn't go too well. Sometimes parties litigate against each other without an attorney. And again, you can do that. The court will accommodate you. But it's sort of like, basically, would you fly yourself on an American Airlines plane from here to Los Angeles if you're not a pilot? Not the best idea. You might be able to figure it out, but something bad is more likely to happen. The timing and activities, though, when you're in the court process, are driven by deadlines, the rules of civil procedure, the rules of family court. And so there's going to be formal paperwork going back and forth. Give us all your bank statements, give us all your IRA accounts, give us all your W-2s, and then you have 30 days to respond and provide them, and you can get 30-day extension of time. And this is what you hear of things going on taking forever. And you may have depositions in order to find out what a witness is going to say, either one of the parties or friends, family members. If you have witnesses who need to testify as to particular elements of the case, you get their testimony ahead of time under oath before you even get to court. And so this, as you can imagine, is an expensive process, and it's a time-consuming process, and it's a stressful process. And the way domestic trials work, in particular, family law situations, it's often a series of each issue, the ones we mentioned on Separation Island Part 1, the alimony, child support, custody and visitation, they're separated out, and you might have mini trial on each one. Sometimes some of the issues can be consolidated together, like equitable distribution and alimony, but not always. And not often. So here you have a lot of, the lawyers are driving the process here. The lawyers are filing what they need to file. They're responding to what the other lawyer is filing. And again, everything that's filed in court, unless you have some very rare situation and there's a confidentiality order, everything is filed with the court in a court process, or will be tried in court and argued in a court process out in the open with other people who could come to court. Not that everybody does. And so there's no confidentiality of proceedings. Now, since I'm talking about this during the COVID pandemic, I should add another factor that's not on this chart, and that is the courts these days are jammed up. And that's just an objective fact. That's not an opinion. Talk to any domestic lawyer and they'll tell you the same thing. Even though courts are trying to adopt and have at least had some success with WebEx or video conferencing or Zoom conferencing, for some things, it's still something they're trying to figure out, and they don't have it down to a science, and there's a massive backlog. And so even more than usual, court process is a tough road to recommend or be excited about for anybody, because things are moving slower even than they ever have before. And it wasn't, super fast before. Pleading is harder. Getting your pleadings filed and back with all the limitations is harder. And you can just multiply what the time expectation is really a lot greater than it usually is. And again, sometimes one party or the other might be engaging in litigation without a lawyer. That's called being pro se. This is best when the parties just can't communicate and there's no hope of it and they don't want to try to. One or both of them is just unwilling to cooperate. Sometimes one party says, yeah, let's work it out, I'd love to. And the other one's like, no, you're not getting anything out of me unless they make me give it. In which case you don't have a choice, and it's good that the court's there to give a remedy. If somebody's just saying, see if you can find me, see if you can find my assets. Okay, that's what the court option is for. But when there's no trust, when there's serious misconduct, there's power imbalances, particularly oftentimes you have to have a trial if there's been abandonment, abuse, addictions, adultery. If somebody's really hide their assets, hide their money, then you might need the court process to subpoenas or discovery orders that make them turn over information. If somebody's not going to volunteer information, then none of the other methods are going to work really well if somebody wants to hide something. Also, if you have complex custody issues or complicated living arrangements, if one parent or another does have to move to another jurisdiction or something, and you have some issues that just have to be decided because they're never going to get on the same page, then it's good that you have the court process to go to. I've got one more option on here that I don't really say much about, but you may hear something about, and that's called binding arbitration. And all binding arbitration is basically the parties commit to hire a private lawyer to serve as essentially a judge. An arbitrator, unlike a mediator, does decide the case. They hear the evidence from both sides and they issue a ruling much like a judge would. I should mention also that we don't have jury trials in domestic matters. It's all judge driven. There are no jury trials, so at least there's that. But here you have a private lawyer serving as an arbitrator, and he does have the power to make decisions. And you can keep this as not happening in a court process. You can have the arbitration in a hotel, in a closet, in a living room, or in most likely a lawyer's office. And so it's private, and you have a little bit more scheduling control. Obviously, the arbitrator may have other matters. You got to work around his schedule and the lawyer's schedules, but you at least have some scheduling control. But you do have to pay for this. You actually have to pay the arbitrator's fees. The parties typically split that. There's a price for hiring your own judge, basically hiring a private judge. So this is a costly method. Usually people who choose that are people who can't agree, but they want a decision. They have to have a decision maker. They're not going to agree. They're not going to get together, but they want to keep it out of the press, out of the public, and they want to control the timing of it. So again, as I said, I revealed my bias. I recommend to many of my clients, if not most of them, the collaborative law process. I'm a trained collaborative lawyer, And I have several lawyers in town that I have a good relationship with that I would try to recommend that the other spouse hire. And that's often a big factor that we look at. But sometimes I'm talking with the spouse who is doing the leaving or is deciding to take the step of separating, in which case the other party probably doesn't have a lawyer yet. Sometimes I'm talking with and end up representing the person who has either been left or been served with papers, in which case the lawyer has already been chosen on the other side. If the other party chooses a collaborative lawyer and a client hires me to be their collaborative lawyer, then we proceed with the collaborative process. If I am representing the person who is initiating the separation proceedings, then one of the first things we do is communicate with the other side, with their spouse, to find out what they want to do. What is the method that they're going to choose? And if we can, I like to try to encourage that spouse to find a collaborative lawyer. And the reason I do that is because a collaborative lawyer knows how to deal with emotions, knows how to deal with the personality dynamics and whatever challenges may come up, and try to not turn that into great fodder for cross-examination and trial material, but rather instead says, okay, given that we have these challenges, how do we solve our problem? How do we enable this couple to move forward, to leave Separation Island in a healthy fashion, and with as much of their resources still intact, with spending less money, hopefully spending less time, spending less stress. And if the other party, I've had the other spouse make several different kinds of choices. Sometimes they do that, they hire collaborative counsel. Those cases have typically gone well. Sometimes the other spouse wants to represent themselves, but they say they'll be collaborative. We can't be an official collaborative proceeding, but we can operate as if we're being collaborative and we're not going to court. The other party would agree at least to abide by the principles of collaborative law, and it's not technically a collaborative proceeding. And so in that case, sometimes I can stay involved if it doesn't work and we have to sue this rascal, which often happens. And the other party may go and get a lawyer who does both collaborative and litigation and gives them kind of a recommendation and may tell them to go one way or the other. And they may hire just a straight up litigator and say, no, see you in court. And if they do that, usually in most cases, then I will recommend that the person who's in contact with me hire a veteran litigator who's in court all the time, who that's how they operate. That's what they want to do. My skill set, I'm great fine in court. I just don't believe in going there, and it's not how I want to use my skills and my time. I think I'm better suited to collaborative law and mediation. And I like working with collaborative lawyers to try to help people navigate this. The other thing I'll say briefly is I recommend collaborative, especially if there are kids involved. If there is going to be a future co-parenting relationship because there are kids involved, then how the parents treat each other and how they get through a separation island and how they set up for the divorce is the most crucial thing. The method that they choose, the process they choose, will determine or at least set the initial trajectory of the co-parenting relationship. And if you are trying to cross-examine each other and prove that one another's not fit or a bad person and all that, then you're going to end up with acrimony and more bitterness. And that's not a great, way to set sail together in this co-parenting adventure you've got. Whereas if you can figure out how to navigate collaboratively, get along, oftentimes the fruit is a healthy, robust co-parenting relationship. And because you have not taken each other out, you've actually taken the opportunity to try to learn how to navigate this stuff together. So as far as next steps, if you've listened to this video and heard this information, call me if you're interested in talking about a collaborative law approach or a mediation approach. If you want a recommendation to a great bulldog litigator, I can get you one of those as well. But I'd love to hear about your case and give you some guidance on this very difficult path that you find yourself on. It's a hard path. It's a difficult path. It's not an impossible one, but we at Osborn Conflict Resolution really love to help guide people. And that's how we view ourselves, as your guides through what is a horrible and difficult process of necessity. We can't make it not horrible and not difficult, but we can certainly minimize the difficulty. And that's what we're here to do. So thanks for listening.